So thank you for joining us today. We are very lucky to have Suzanne and Séverine on today. I met both of them at through or via the International Academy of Family Lawyers. So for those of you that don't know, this is a group of very well-respected, very accomplished family lawyers, and you have to have done some pretty good things to get the nod and be invited to join. So I met them a couple of years back, and my first ever where Nedbank were involved in sponsorship of the Academy. So Suzanne is head of the family team at Withers, and Séverine, as I said, a fellow at the IFL, hugely experienced, or both of them hugely experienced international high net worth divorce lawyers. So today the topic is the impact of jurisdiction on divorce. And I think with the last 12 months in particular, there's been a lot of movement. So therefore, this is probably becoming a particularly hot topic at the moment. And in terms of the format for today or the agenda, we're looking at what guides the decision in terms of where the divorce is held, why the UK is currently a very popular destination, I think predominantly for the weaker financial party. Now, they in terms of the jurisdictions we're going to look closely at today, really, and look at the nuances, it will be the UK, France, and Italy, as Séverine and Suzanne have knowledge in those areas. And then looking at the popularity and effectiveness of pre and post nups. Now, I won't hang around for too long because we have a lot to cover in a shorter space of time. So I will hand over. I don't know who's going to go first, or we're going to sort of interact with you between the two of you, but off you go.
I'm happy to go first. Decisions, locations for divorce can have a massive, massive impact on what somebody receives at the end of the process. And that's why Séverine and I, it's one of the first and most important things that when we're speaking to clients, we find out which jurisdictions, if any, might there be a divorce in? And then the second question is, depending who you're acting for, which is the best jurisdiction for that person to get divorced in. So things changed a lot for us here in England post-Brexit. Before Brexit, we had what was called the first in time rule for our European counterparts. So I would quite often be sending somebody on the Eurostar to Paris or on a plane to Milan because that was the best place for them to be starting, and Séverine will explain why in a minute. Those rules fell away with Brexit, so we now are back to square one when I qualified in 1999, and we have the good old forum dispute, forum non conveniens, which is a good old Latin phrase, which is the best place to get divorced. And what we're looking at from an English point of view is where are people living? I think there's a bit of a myth that it depends on where you got married. It's where you're living at the time of the divorce, where you are habitually resident from an English point of view, but also from an English point of view, because the English divorce court has lots of tentacles, where you are domiciled. And obviously that's having a big impact at the minute with the number of people who are leaving the UK at the minute because of the nice changes in the tax rules. So it's now a discretionary system. If we end up with two countries fighting, we will have a look at where they're living, where the children are living, where they're educated, where their assets are located, where they plan to retire, where the proceedings are, where proceedings might be quicker, and all of that sort of stuff. English judges only apply English law because the English judges think they know best. Not saying anymore. Whereas from a French point of view, it's very different and a continental point of view. So what we're seeing now is forum disputes between England, London and Paris, between London and Milan. Some of you might have seen Andrew's LinkedIn post about today. I had an Italian case where one of the factors was, where is the Vespa parked? You know, where is their centre of interest? Where is the hairdresser and the gym and the church and all of those sort of things? So I think the most important thing for all of you is just that red flag when you're working with your clients, and getting advice early is super important.
Could I ask, are you saying before Brexit that people could get divorced and they could choose wherever in Europe they wanted to get divorced?
You still can choose. Before Brexit, if I filed in London at 10 o'clock and did everything properly, and Séverine filed in Paris at 11, I won because I was literally first in time.
Right.
Whereas now, if we did that then the courts have to decide which is the most appropriate place.
Yeah, thank you.
And sorry, Suzanne, when you talk about going to that embryonic level where you're talking about where's the hairdresser, is that only where it's a close call type thing?
I mean, sometimes it's really obvious that it should be in Paris, for example, because, everybody's been living here and maybe one of the parties is still domiciled here. So there's very tenuous links. Whereas in other cases, you sort of do that deep dive.
Yeah.
You have to have a link to get divorced in a country under their rules.
So from the English point of view, and Séverine will cover the French point of view, from an English point of view, someone needs to be habitually resident here, so to have their centre of interest here, or someone needs to be domiciled here. So you need to have the hook effectively to start the proceeding.
So some points are similar in France and the UK, but in France the big difference is that we are still in the European Union, so we apply, of course, European regulations. And the one about divorce, the main one about jurisdiction of divorce, is the Brussels II ter. So we have very, very specific criteria, and they are alternative. They can be there could be many criteria that a case would meet, or they could be known, but mainly it is the we can say that it's the habitual residence, like Suzanne was saying, that's really the criteria that's the most important, although nationality is important, because if two people, if the spouses are both of the same nationality, within the EU, two French people could always come to France to divorce, even if they have never lived as a couple in France. So, it happens quite often because French people, if they agree, they would. It's usually when they agree, they choose France to come back and have a divorce in France within their own culture and what is familiar to them. But really, what we know and what we fight about is the habitual residence, and because there's no definition about habitual residence on the European level, so it's quite a practical and subjective issue judges deal with, like Suzanne was saying, where's your hairdresser? But it's the intention of the intention of transferring your main interest in life in one country or the other. But that creates huge litigation. You could be litigating for 3 years, 4 years, all the way up to our Supreme Court, just to know to have a judge ruling which country is going to be competent, because you have this race jurisdiction race that Suzanne was telling you about, where we seize two countries literally at 5 minutes or a day, and a difference, and then it's the start usually of quite a long litigation. So the best is to avoid it, obviously, and I guess that's the goal, by thinking ahead, if I may say. You can't always.
No. Okay. It's in reality is where people are either from or where they're on planning to be from. That would probably be the biggest deciders. They're the things.
Nothing to do with where they got married. That's what people have this wrong perception. Yes, where they got married and where they first lived after marriage has an impact on the law applicable to their matrimonial regime and the splitting of assets, but not on the jurisdiction itself.
Okay, thank you. Mm-hmm. And then one of the other topics, obviously, the UK is known for being a relatively popular destination for. Is it the weaker party that essentially it's more advantageous? So why is that?
Yeah,
are there other destinations that are better for the stronger party, I suppose, that would be?
Well, I was in fact instructed by one person many years ago to tell me where was the best place in the world for him to go and get divorced, and he ended up in Sweden because you basically didn't pay anything. He was a big tech person from Silicon Valley, so we sent him and his whole family to Sweden. Anyway, I digress. I in fact was at a debate on Tuesday night. One of the law firms in London held a debate about whether or not London will continue to be the divorce capital of the world, given the change in the exodus of a lot of the high net worth individuals. But I think the reason why we got the strap line, which is, I'd rather be like Paris and be the city of love than the divorce capital of the world, it is because 20 years ago, the law changed fundamentally here on divorce. And we have the starting point is a 50-50 split of everything, not only that's been built up during the marriage, but also during a period of cohabitation if it seamlessly moves into a marriage. So that can have a big effect. We also have this concept of sharing, and that can put shivers down the spine of people if they have pre-acquired wealth or inherited wealth and that sort of stuff. But the most important thing is we have a concept of needs, and everybody's needs have to be met in the event of a divorce. That can be basic needs, reasonable needs, or generously assessed needs. So what happened was there was a string of very, very high profile divorces over the sort of 2000s and the last 2 decades. The pendulum is swinging back, I think, and I think we are getting better at assessing what is matrimonial and non-matrimonial. The difference between England and Scotland has very, very clear rules about you separate and the guillotine comes down on the value of the assets that day. In Scotland, the maximum spousal maintenance you can get is 3 years, and apparently that's on a good day. So it's very different from an English court's point of view. So I will hand over to Séverine, who will say why you would or would not want to be in Paris.
Yes. Basically, generally speaking, unless you are two French nationals who are agreeing on everything, then our role here as lawyers is very small. You don't really want to divorce in France. And unless, and sorry for what I'm going to say, you want to be able to lie and dissimulate assets, because here our judges have very little power really to enforce disclosure. That's very important. It's very difficult in France to enforce disclosure. International disclosure. It's even hard within France, but at an international level, it's really hard. Also, France is very bad on the tax point of view, because we have a tax on splitting assets, meaning a tax on all worldwide assets would apply when splitting assets when divorcing. It's a 1.1% tax. Basically on all assets. So that's quite.
So would that apply, Séverine? Let's say you had a person with £100 and they were going to keep 50 and give 50 to their spouse. Would that 1% or 1.5% apply to the £100 or just the £50?
The 100. The
100. Okay.
Yes. So that's very significant. Yes. Also in France, we don't take into consideration the cohabitation period. That's a big difference. We only consider the years of marriage, and that can have an impact for the weaker party, of course, because of course it reduces the rights to compensation if you have a shorter marriage.
It's a crazy quirk of English family law, because as a cohabitee you have no rights. But yet, if you cohabit and then you seamlessly move into the marriage, then suddenly this 10 years has some value that if you had just walked away from the relationship, you would have nothing at all. I think the other thing, just to pick up from Séverine's point of view, is we have the opposite in terms of disclosure here. There is a duty to give worldwide financial disclosure, and the court has quite sweeping powers, including the ability to send someone to prison. And in fact, I remember a case where the husband actually turned up to court with his Louis Vuitton suitcase because he was in breach of so many disclosure orders that he knew the High Court was going to send him to prison. So he went with his suitcase. And that's something that a lot of people want to avoid. As Séverine was saying, they don't want to give that worldwide financial disclosure.
One big difference, if I may add, is also how the law treats the matrimonial home. Is very different in France and England. Matrimonial law, I mean, Suzanne, you can confirm, but matrimonial domicile home is really usually split 50-50, regardless of who has paid for what. In France, you could have been married and live in a house for 30 years as a family, and as a spouse have nothing in the end of it.
Okay.
If it's the main asset, that's quite.
Sorry, I thought you said the house was split 50-50.
I mean, it's more likely to be included in a split that would be like say a fair split. It's not as strict as in France, where we calculate the rights, but we might see that with the prenups subject that we will have next.
Yeah, which probably takes us. And in fact, Suzanne, was there anything you wanted to touch on Italy specifically in terms of?
No, I mean, I think so. I'm an English lawyer, but I do quite a lot of Italian work, and I think the Italian courts follow the French courts quite a lot with their matrimonial property regimes. I think one of the Italian courts had a massive change in procedure 2 years ago. So they used to have lots of different courts dealing with lots of different proceedings, and they've all been brought under one big umbrella court now, which is causing lots of chaos for the Italian family lawyers. But I think the biggest change in Italy, so it used to, in Ireland, you used to have to be separated and then wait 4 years for a divorce. That's now changed. In Italy, it was, you could be separated and you would have 3 years then before you could start divorce proceedings. But now in Italy, you can start your separation proceedings and it continues into a divorce. So there used to be a lacuna in between where if we could get in with an English divorce petition, once the Italian separation proceedings had closed, our English divorce petition would be the first one that was there and waiting. But the Italians have closed off that hole in the legislation. So they have.
Okay, thank you.
And then, so as Séverine said, sort of the last topic that is part of the agenda was going through prenups and their effectiveness or their different versions in different jurisdictions. So I didn't know if who wanted to.
Séverine, do you want to cover that?
Just yes, because for me it's quite straightforward, if I may say. We only have 3 types of prenups or no prenups, basically. We are very restricted in what to include in the prenups. There's a lot of things a lot of points that are considered as for example, you cannot plan how much you're going to compensate at the end of a divorce, for example. This is you cannot add that to your prenups when you decide, when you choose to have a prenups. A lot of people still do not have prenups, less but than before. But so if you don't choose, if you don't have a prenups, it will be everything that you've acquired during the marriage. Would be joint. But more on an international point of view, interpretation of prenups it creates lots of litigation. So when prenups are drafted, it's important to get really good advice, and because it could be really a source of major litigation when the divorce comes, And if there's no prenups, then there's litigation on how to interpret the foreign law, because you could be divorcing in France. Two French people have been expat in China, for example, and they got married there, and they lived there without a prenups. They come back, they divorce in France. Then we're going to apply Chinese law to the liquidation of the assets. Not to the divorce, but to the liquidation of assets, because in France, there's big difference, also a split between the divorce and the splitting of assets. So people find out which law they are under when they get divorced. And sometimes it could be, surprising, could be quite exotic. So, and the French court might have to apply, for example, California law or any law in the world, really. And us lawyer, we have a huge task in teaching basically the judges, the courts, what the foreign law says. And then it's a debate on how to explain and interpret a foreign law in France to courts. And that's also lots of litigation.
Why the English judges only deal with English law.
Yes, I know. They even ignore foreign
I think
prenups.
they're getting better. Finally getting better. So it's the complete opposite from an English court's point of view. Whereas in France and Italy, you have your strict separate property, community of property regimes. We don't have any strict matrimonial property regime, and in fact, we've only really done prenups for the last 15 years. when there was a big case that went to the Supreme Court. She was a German heiress worth 100 million, and he was a French banker. They had a German marriage contract that said she keeps hers, he gets nothing. Roll forward 10 years and he's given up his job at the bank. They're living in London. They get divorced. And he got 5 million at the High Court level, which we all thought was fine because he gets a roof over his head with his kids. And she said, I'm not paying anything. My German document said nothing. The document wasn't translated into French. He spoke no German. There was no financial disclosure at all, and he had no legal advice. But as they say, bad cases make good law or bad law. I'm absolutely convinced that if he had been a she, that would not have been the outcome in the Supreme Court, because no Supreme Court would have left a wife after 15 years with money on loan for a property for 5 years, and somehow they capitalized child maintenance at £1 million. I don't know how you need £1 million to look after 2 teenagers, but anyway, that's what they did. But out of that case, effectively, prenups have grown from an English perspective. The Law Commission reported 10 years ago, as with all good Law Commission reports, it's sitting in Westminster gathering dust. Nothing has happened. But we have 3 rules that effectively we follow. Ideally, the prenup is signed off and in the bottom drawer 28 days before the wedding. Everybody has to have legal advice. That would include international advice, as Séverine was saying. And you have to give not just financial disclosure, but material disclosure. So if you may be inheriting at some point in the future. The prenups from an English point of view, unlike the French point of view, we can have a tariff, which is a bit like the US approach, which is why Tom Cruise got divorced when he did, because he was about to have to pay a lot more money if he'd gone into the next year of his marriage, or the more woolly English reasonable needs. So a roof over someone's head and sufficient maintenance from that point of view. And Séverine is completely right. For almost the last 15 years, the English courts have completely ignored the European marriage contracts, but we in fact had a case last year, which was BI versus BN, because the English judges have decided they're going to make funny names up. There was an art case, which was GO versus Goya as well. Anyway, BN, basically, they French, but they married in Hong Kong. They had their French séparation de biens. They had 115 million, but during the marriage, they put 105 million into the husband's name in trust. And they were here by the time they were getting divorced. So she thought she was going to get her 50%. And actually, the English court did take into account what the French court would have done and said, you knew what would happen if you put that into the husband's name. So she didn't get her 50%. She got only 22 million. But if it had not been for the French marriage contract, the séparation de biens, then she would have had more than 50 million. So those documents now are having more and more weight, which is something that, 3 to 5 years ago, Séverine and I weren't seeing at all. If you had a European marriage contract, it was a bit like.
If I may add something, that's very important when there's real estate assets based in France, and you have a divorce abroad, who's been ruled or by consent without really good advice, if this divorce order from abroad, like from England, I've had several cases like this, and they are really, really difficult, does not take into consideration the prenups, the French prenups. When it comes to splitting the real estate in France, then the notary will not want to and cannot do anything else but applying the French prenups. He's bound to. So that creates big problems, because the law, the framework, the notary cannot work with the divorce that's been pronounced somewhere else in another country without taking into consideration properly, and that could lead to and one party might want to take advantage of it if it's really litigating, because then okay, well, we can't apply what the English judge say. Let's go by the prenups, and then there's a huge work to sort of like go back to court, get the exequatur of the decision in England, to enforce it, and then even though sometimes we're stuck for 5 years, and you can only get out of this by consent. The law it is impossible to get out of a tricky situation like this with the help of the law, at least in France.
A quick question on the prenup. So if you have an international, there's a couple from two different countries and they've lived in different places and they may be going to live somewhere else, they may have earmarked going to America, let's say. Would you have to get multiple prenups or similar type things in different jurisdictions? Is that like the sensible approach, or is there, or not?
I mean, ideally one document, if we can work it in those international cases, ideally one document, because it goes back to Severine's very good point, which is if you come to unpick it and you've got 3 different documents, I've just done one with Scotland, London and California, but we've got one document that covers all 3 jurisdictions.
In France, it's very hard because once again, we are very formalistic. I mean, the notary who was drafting the prenups with the help of lawyers or not, but is very limited in what can be planned. So really, it's difficult to plan with French law. It's difficult to plan all situations in all countries, basically. And we go back to a typical, most of the time, we would go back to sort of like a typical French prenups, which that will not be enough.
And would you need to get it translated into, let's say, if you're in multiple countries, do you have to get it translated into every country that it may impact, or is that just a nice to have, but you don't need to do that?
The parties, what is important is that the parties understand and are to assure their consent.
Yeah.
And you can always have it translated later in the country.
Yeah.
To be applied.
I had one case last year where there was a ceremony here, but they were moving immediately to Italy afterwards, and they were originally from the Middle East. And the ceremony here wasn't recognized as a valid marriage from an English point of view, but under Italian law and the law of their country in the Middle East, it was recognized as a valid marriage. So we had to have a sort of a contract here in case they decided not to move to Italy, but deal with the prenup from an Italian perspective, because it was going to be treated as a valid marriage if they'd moved there, as was the plan.
Okay.
And also just have a civil ceremony here as well as the religious marriage.
They could have had, but they didn't. They just had the religious marriage.
Yes, validity of marriage is another subject. Like get married. I have had 2 cases of French people who got married in Las Vegas and they thought they were not married. They came back and they thought it was some kind of game, some kind of like joke. And and then they bought houses, they did things, saying like unmarried people because they thought it was some kind of. But then the notary found out that they actually got married in Las Vegas, and that was a totally different story. And even for inheritance, it has huge. So you have to be careful where you get married and what and how you.
Yeah, don't get joke married even in Vegas.
Now, as long as the marriage is valid in the country where it was celebrated, that's all what it takes to be married.
Then I know there's some religious marriages in England. Some are valid and some aren't. Because I used to work with a guy who was part of a group. Is it? I don't know. About getting these marriages recognised, or about getting people to understand it wasn't valid, and they needed a civil ceremony as well.
Correct.
Otherwise, you find they come to get divorced,
And they're
they're not married, and usually the wife ends up losing.
yeah.
Yes.
No, absolutely. Well, we have slightly overrun. I knew we'd run out because as we touched on, Séverine and Suzanne, this is a massive topic, and thank you very much for going through and covering it at a great level that even I could understand. So that's helpful. Guys, thank you very much. I really appreciate it, and I look forward to seeing you again soon.
Happy Friday. Take care.
Thank you, everyone. Thank you.
Bye.